SKATES Sad Part 2. You can sue, sorta. I know suit remedies and obstacles. Securing limited remedies and repairs, methods. Identification and removal of individuals with no legal status remains the purpose of Immigration and Customs Enforcement, ICE. So the agency enforces federal immigration laws, legally, and notwithstanding the Kavanaugh footnote, United States Immigration and Customs Enforcement, ICE, has no legal authority to arrest or deport United States citizens for immigration purposes. Jurisdiction is limited to enforcing federal laws and the removal of non-citizens, notwithstanding customs and trade. In the 2025 case, Justice Brett Kavanaugh claimed in brief investigative stops American citizens or legal residents mistakenly stopped by immigration agents would be promptly let go in a concurrence opinion regarding immigration enforcement. He said in his now described Kavanaugh stops, regarding Hispanic residents' apparent ethnicity could be a relevant factor in federal agents' decision to stop them and demand proof of citizenship. In Justice Kavanaugh's concurrence in Noam v. Vasquez-Perdomo, he'd said federal immigration officials could use factors, such as apparent ethnicity, in making stops. Legal scholars said descriptions of brief stops and prompt release sanitized reality. United States citizens were being detained for extended periods. ICE and Border Protection used his opinion as a license to stop any Hispanic person on the basis of race, often with excessive, even sadistic force. In what became standard practice, the agencies jailed them until they proved their lawful presence. Federal agents began to kidnap, torment, and brutalize people. These included many United States citizens, due to their ethnicity. This was even after such kidnapped people showed legal status. If the person is a United States citizen or otherwise lawfully in the United States, that individual will be free to go after the brief encounter. If the officers learn that the individual they stopped is a United States citizen or otherwise lawfully in the United States, they promptly let the individual go. However, the reality doesn't track. While ICE cannot legally arrest you because of your immigration status, since you are a citizen, citizens are sometimes detained or arrested under specific circumstances. Now Justice Kavanaugh wrote words to the effect that it was clear the Fourth Amendment requires that immigration stops must be based on reasonable suspicion of illegal presence. Stops must be brief. Arrests must be based on probable cause. And officers must not employ excessive force. Officers must not make interior immigration stops or arrests based on race or ethnicity. The case of Whitron v. United States prohibited selective enforcement based on race. While many still adhere to deference to executive authority, some cases do not show a judicial concern over federal misconduct patterns. Obviously, these days, federal authorities in the streets appear to be ignoring all this. Further, the Fourth Amendment protects individuals from unreasonable searches and seizures by the government. This is supposed to safeguard their privacy in their persons, houses, papers, and effects, and requiring warrants to be based on probable cause, supported by oath, and specifically describing what to search or seize, though exceptions exist for situations like consent or exigent circumstances. It ensures that law enforcement generally needs a warrant, issued by a judge, for searches, especially in private spaces, and prevents arbitrary government intrusion. The Fourth Amendment is supposedly to provide security in private spaces, protects your home, body, documents, and belongings from government intrusion. Reasonable expectation of privacy governs when police need a warrant, generally when there's a reasonable expectation of privacy, like in your home. Warrant requirements mandates that warrants must be supported by probable cause, strong evidence, be sworn to by an oath or affirmation, particularly describe the place to be searched and the people/items to be seized. Freedom from excessive force analyzes the use of force during stops and arrests as a seizure of the person, ensuring it's not objectively unreasonable. What constitutes a search and seizure? Search: an intrusion into a person's reasonable expectation of privacy or a trespass into a constitutionally protected area. Seizure of a person, a meaningful interference with someone's freedom of movement, like an arrest or investigatory stop. Exceptions when warrants aren't required. Consent, you agree to the search. Search incident to lawful arrest, to find weapons or evidence near an arrested person. Exigent circumstances, emergencies, like hot pursuit or preventing evidence destruction. Plain view, evidence is visible without a search. Vehicle searches, probable cause to believe a vehicle contains contraband. Recapitulation. The Fourth Amendment is foundational to privacy rights, preventing general warrants and arbitrary government actions, and is increasingly important with new technologies like digital data and surveillance. While a United States citizen detained by ICE cannot be deported, ICE sometimes detains citizens in error. For example, ICE may detain U.S. citizens based on misidentification, outdated records, or confusion about a person's citizenship. If you are a U.S. citizen and ICE stops you, strive as indicated here to protect your rights. You have them, although remedies may be delayed and effected sometime after. Among the more relatively immediate, if ICE has detained you or a beloved, a bond release can be sought if one has the means, even if the agency may attempt to slow walk. Still, mistaken arrests happen, or what they claim them to be. Prompt action prevents complications, secure your release faster, and ameliorate stress from immigration officials who may wrongfully detain. Still, you have specific legal protections and the right to seek justice. But know this may be delayed. Nevertheless, wrongful detention violates your Fourth and Fifth Amendment rights. And ICE has no legal authority to deport citizens, although there are instances in which it has done so. Refresher, the Fourth Amendment ostensibly protects people from unreasonable searches and seizures, stating that warrants can only be issued with probable cause, supported by oath, and must specifically describe the place to search and items to seize, ensuring security in personal effects, homes, papers, and persons. The right of the people to be secure in their persons, houses, papers, and effects, against unreasonable searches and seizures, shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched, and the persons or things to be seized. More protections are found in the Fifth Amendment to the United States Constitution. This reads in pertinent part. Fifth Amendment. No person shall be held to answer for a capital, or otherwise infamous crime, unless on a presentment or indictment of a grand jury, except in cases, when in time, of public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall any person be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property, without due process of law, nor shall private property be taken for public use, without just compensation. Your rights. You have the right to remain silent. If you wish to exercise that right, say so out loud. In some states, you may be required to provide your name if asked to identify yourself. You do not have to consent to a search of yourself or your belongings, but police may pat down your clothing if they suspect a weapon. Yet ICE and Border Patrol continually effect abuses. Immigrants' rights and detention. An immigration enforcement strategy that has increased shows immigrants, lawful permanent residents and asylum seekers are being detained for unlawful time periods. This is without any finding the immigrants are a danger to society or a flight risk. As told above, the United States Constitution's the Fifth Amendment protects against self-incrimination, giving the right to remain silent, double jeopardy, being tried twice for the same crime, and ensures due process of law, fair legal procedures, and just compensation, if the government takes private property for public use. It safeguards individuals from being forced to incriminate themselves and supposedly guarantees fair legal treatment by the federal government. Oftentimes these days, a myriad of agencies ignore these rights. Both the Fourth and Fifth Amendments apply to anyone in the United States. Anyone. Without regard to status. Thus, United States citizens and naturalization and some green card remedies. Filing Federal Tort Claims Acts claims. Emotional distress. Gather documentation, collect as much evidence as possible, proof of your citizenship or residency status, records of your detention, and any documents showing harm or damage, such as lost wages or medical records. Hire counsel, if possible, with experience in Federal Tort Claims Acts and wrongful detention. Prior to suing, you must file an administrative claim with the appropriate federal agency, detailing the who, what, where, when of what happened and the damages you seek. In response, the government will have 6 months to investigate and respond to your claim. If they deny your claim or do not respond timely, you can then file a federal court lawsuit. Some citizens' remedies. File a wrongful detention claim. Mistakes happen, if they are mistakes. Some employee actions occur deliberately. Either way, this causes United States citizens or green card holders to be wrongfully detained by ICE. A United States citizen or green card holder wrongfully detained by Immigration and Customs Enforcement, ICE, has recourse to the right to sue. As stated in Part I, in reality, you are not suing the agency ICE, or its individual employees specifically. You are suing the United States government. This is under what is called the Federal Tort Claims Act, FTCA. This legislation lets the wrongfully detained hold the federal government responsible for wrongful acts carried out by its employees, including wrongful detention. This allows individuals to sue the federal government for tortious acts, like false imprisonment or negligence, committed by federal employees. File an administrative claim, Standard Form 95. Before you can file a lawsuit in court, you must first file an administrative claim with the Department of Homeland Security, DHS. This gives the agency a chance to investigate and potentially settle the claim without going to court. Don't count on that. It basically stalls the case. Within the information one has to provide, you must include a specific dollar amount, for the damages you are seeking, such as lost wages, emotional distress, or medical bills, cars damaged, windows knocked out, medical bills, etc. Agencies have 6 months to respond. Within that time, if it fails to respond or deny the claim, you can then file a lawsuit in federal district court. Pre-claim actions. Gather your supporting evidence. Citizenship proof, such as passports, naturalization certificates, or birth certificates. Any detention records paperwork that ICE provided you. This includes any forms, such as a notice to appear or discharge papers. If possible to ascertain, list any recorded or written names, badge numbers, patrol car numbers. These will prove important later. Know the agencies will respond with untruths, or out-and-out lies. List any damages, such as pay stubs, for lost wages, medical records, if you were injured or denied medications, and witness statements. Affidavits, or declarations as the case may be. Note that a more comprehensively discussion later, an administrative warrant, signed by an ICE official, proves not the same as a judicial warrant, signed by a judge. Administrative warrants do not allow ICE to barge into your home. Judicial warrants may, depending on the particularity with which they are written. Part of the damages may be busted doors, locks, hinges, and windows. The excuses. ICE's mistaken detention of United States citizens. ICE officers may detain individuals due to mistaken identity, documentation errors, or other agencies' miscommunications. Detentions occur during routine checks, at work, or at home. Prove United States citizenship if ICE detains you. Regardless of a person's immigration status, everyone is granted certain rights and protections under the United States Constitution. These rights include, but are not limited to, the right to due process, the right to legal representation, the right against unreasonable search and seizure, the right not to be arrested or detained without a valid reason, the right to record interactions with law enforcement. Knowing your rights and protections under the Constitution is the first line of defense. Misidentification, having a name similar to someone on an ICE warrant. Unclear documentation, issues can arise for citizens born abroad to United States parents if their citizenship paperwork is incomplete or complex. Note, if a United States citizen is wrongfully detained, they are legally entitled to immediate release once their citizenship is verified. Hundreds of United States citizens have successfully sued the government for wrongful detention following these types of errors. Mistaken arrests happen, but knowing your rights and the steps to take immediately can protect you and help resolve the situation quickly. Recognizing why ICE might detain a United States citizen helps you prepare for the next critical steps. ICE officers may detain individuals due to mistaken identity, documentation errors, or miscommunication with other agencies. Detentions can occur during routine checks, at work, or even at home. You can focus on your rights and act immediately if you are wrongfully detained. Yes, ICE can deport United States citizens by mistake, but such a deportation is against United States law. Proof of citizenship. United States citizens are not legally required to carry. However, having access to copies of key documents can help resolve a mistaken detention more quickly. When ICE detains someone, the fastest way to resolve the situation is often by providing clear proof. ICE should release a United States citizen as soon as officers can verify citizenship through reliable documentation or legal intervention. Common documents used to prove. The following documents are commonly accepted as proof: United States passport or passport card. A valid or expired United States passport is one of the strongest forms of proof. It confirms both identity and citizenship. United States birth certificate. A birth certificate showing birth in one of the 50 states, the District of Columbia, or certain United States territories generally establishes citizenship. Certificate of naturalization, issued to individuals who became United States citizens through the naturalization process. Certificate of citizenship, issued to individuals who acquired or derived citizenship through United States citizen parents. Consular report of birth abroad, Form FS 240. Issued to individuals born outside the United States to United States citizen parents who met physical presence requirements. In many ICE detention cases, the individual does not have these documents on their person. In those situations, family members, attorneys, or consulates may need to provide copies directly to ICE officers or supervisors. Born outside the United States to United States citizen parents. Individuals born abroad to United States citizen parents may still be United States citizens at birth, but only if statutory requirements were met at the time of birth. These requirements can vary depending on whether one or both parents were United States citizens, the parent's marital status, and how long the United States citizen parent lived in the United States before the child's birth. Adopted from another country. Children adopted from abroad by United States citizens may automatically acquire citizenship under the Child Citizenship Act of 2000, if the child was under 18 at the time. At least one adoptive parent was a United States citizen. The child entered the United States as a lawful permanent resident, and the child was in the legal and physical custody of the United States citizen parent. If you never completed the citizenship paperwork or do not know what to look for, a lawyer can help. Naturalized citizens with incomplete records. Naturalized citizens may face detention if ICE databases do not reflect updated naturalization records. Name changes, old A numbers, or clerical errors can cause ICE to rely on outdated immigration information instead of the current citizenship status. What if you do not have proof with you? Officers may continue holding a United States citizen detained by ICE until someone provides documentation of their citizenship and verifies it. An attorney can contact ICE supervisors directly. Submit proof electronically or in person. File emergency court motions or habeas corpus petitions, requests to end unlawful detention, and advise you on your constitutional rights. If ICE does not believe my documents. If ICE disputes documentation, an attorney can escalate the matter to supervisors, agency counsel, or federal court. ICE must investigate credible claims of citizenship. Following the illicit ICE detention. Again, legally, ICE cannot arrest or deport United States citizens, but wrongful detentions do occur due to errors like misidentification, outdated records, or unclear citizenship documentation. Assert your citizenship, provide proof, if possible, stay calm, avoid signing documents, and if necessary, request an immigration attorney. Different legal standards are used by ICE, or should be, for United States citizens and green card holders. Permanent residents, under certain conditions, can be detained by ICE lawfully. Lawful permanent residents, also known as LPRs, or known as green card holders, can be detained by U.S. Immigration and Customs Enforcement, ICE, if they commit specific acts that render them removable under the Immigration and Nationality Act. Green card holders' detention rights. The right to remain silent and should not sign any documents, such as a stipulated order of removal. This waives their right to stay in the United States. Beware the trickery of having one to sign without the ability to read or understand the document, or such being in a language of which the LPRs remain unfamiliar. To be represented by an attorney. But in immigration court, the government does not provide a free one. In summary, generally, green card holders LPRs must carry proof of status. Always carry your valid green card, as LPRs are legally required to have evidence of their registration in their possession. Albeit, it might prolong an encounter, and even arrest, one should exercise silence if stopped by ICE. Green card holders have the right to remain silent. You do not have to discuss your country of birth or how you entered the U.S. Usually, something said will bolster the ICE or Border Patrol's position. Do not sign documents. Signing any paperwork can waive your right to an immigration judge hearing. Immediately request a lawyer if you are taken into custody. ICE must allow you to contact legal counsel. When they will allow remains problematic. Back to United States citizens recap. Reasons recapitulation where ICE detains U.S. citizens include misidentification, confusion with someone who has a similar name. Outdated or inaccurate immigration records in federal databases. Where one is born abroad to United States citizen parents, and the citizenship documentation is incomplete or unclear. Mistakes in verifying that someone is a naturalized citizen. Although ICE supposedly cannot deport U.S. citizens, expeditious legal help remains essential because of these mistakes. Notwithstanding the long shots expressed in Part 1, some limited remedies prove possible. Rights in suing ICE for detaining a United States citizen or green card holder. You are technically suing the United States government, not ICE as an agency. The Federal Tort Claims Act, FTCA, covers wrongful detention, false imprisonment, and other harms caused by government employees. Wrongful ICE detention is a violation of civil rights that can result in an actionable claim. This is because it goes against the constitutional right to personal freedom and liberty that every United States citizen and green card holder is entitled. The FTCA allows people to seek compensation from the government for damages resulting from wrongful acts by federal employees. If ICE wrongfully detains you, the FTCA provides a path to file a claim and potentially a lawsuit. The important points. When detention is unlawful, it may be possible to pursue compensation through an FTCA claim for time unlawfully spent in detention, emotional distress and mental anguish, lost wages and loss of employment, damage to reputation. This is because the court acknowledges that wrongful detention inflicts genuine and measurable damages. At the same time, not every wrongful detention proves similar. Some incidents last just hours. Others lasts weeks or months. Detention lengths, ICE officers conduct, that of private prison employees, and the severity of harm add to lawsuit damages. Beware the FTCA strict deadlines and detailed evidence are required. While a citizen or green card holder can do it, it is best in hiring an attorney experienced in such matters. The Federal Tort Claims Act proves an effective vehicle for those wrongfully detained by ICE or Border Patrol agents. Hold the government accountable. Prevent mistakes in the future. Claims under the Federal Tort Claims Act. Prompt and proper processing. Enacted by the United States Department of Justice, regulations can be found at Volume 28 Code of Federal Regulations, Part 14. This covers the handling of administrative tort claims. It also gives information on the claims process and the evidence and information to be submitted to buttress claims. And the Federal Tort Claims Act, FTCA, 28 United States C 1346, 2671 to 2680, provides for monetary damages for harm or destruction to, or loss of property, for personal injury or death, caused by a federal government employee or private prison employee's negligence for wrongful acting within the scope of his or her employment. Consult counsel with FTCA claims and wrongful detention experience to assist your claim preparation. While it may be possible for one to do so, because of the strict timelines, it might be best to seek help. Oftentimes, law libraries or online legal sites might provide guidance. If you have to do it, if you believe you have suffered personal injury or property damage because of an act or omission by an ICE employee, complete and sign a standard Form 95, claim for damage, injury, or death. Gather documents, collect as much physical and or written evidence as possible, proof of your citizenship or residency status, records of your detention, and any documents showing harm or damage, such as lost wages or medical records. As another option, you may provide written notification, such as a letter, describing what happened, when, and by whom. To the best of your ability, provide a sum certain, total dollar amount claimed in damages, sign and date the claim. Provide supporting documents. Prefatory administrative claims to an agency under the FTCA must be received within 2 years of the date the claim accrued. Before you can sue, you must file an administrative claim with the appropriate federal agency, outlining what happened and the damages you seek. Wait for a response. The government will have 6 months to investigate and respond to your claim. If they deny your claim or do not respond, you can then file a lawsuit in federal court. If known, provide the name of involved ICE employee. Responsibility for processing administrative claims made against the agency is through the Office of the Principal Legal Advisor. This is within the United States Immigration and Customs Enforcement, ICE. Here, you or your representative must fill out the claim form completely. Include who, what, where, when, detail as much as possible. Submit related supportive documentation. This includes receipts, 2 appraisals or repair estimates, ownership proof of claimed property damage, to the extent possible, photographs, medical documents or records, as well as ICE, Border Patrol, private prison employees, police, incident or witness reports, declarations or affidavits as allowable. Delay in claim filing or submitting incomplete information might hamper information gathering, difficult lengthen the process review, or miss a statutory deadline. Claim filing recap. Processing a claim. ICE takes the responsibility to fairly adjudicate claims seriously, and all claims are thoroughly reviewed. Please allow up to 6 months for ICE to fully adjudicate your claim. Completed and signed forms or other written notification, along with the documentation supporting, should be submitted to Office of the Principal Legal Advisor, District Court Litigation Division, 500 12th Street SW, Mail Stop 5900, Washington, D.C. 20536, or OPLA-DCLD-tortclaims@ice.dhs.gov. What to do when you're released. Write down what happened to you or ask someone to write it down. Include details like names and badge numbers of the ICE agents and anything that was said or done during the encounter. Native Americans are citizens of the United States. Native Americans who believe ICE violated their rights call the Native American Rights Fund at 303-447-8760. Although Immigration and Customs Enforcement, ICE, has no jurisdiction over citizens on immigration matters, ICE targets more frequently tribal citizens and descendants. Conclusion, and prior to federal torts claim filing. If the police or an ICE agent seeks access to a private space, employees are allowed to ask without being tossed against the wall or on the floor for that agent's badge number and to inspect the required judicial warrant to determine whether it is valid. State your citizenship, clearly say, I am a United States citizen. Ask if you are free to leave. If they say yes, walk away calmly. But you have the right to remain silent. You do not have to answer questions about where you were born or how you entered the country. Do not sign documents, without counsel or someone knowledgeable present, lest you waive your rights, inadvertently. Ask for a judicial warrant. If ICE comes to your home, they cannot enter without a warrant signed by a judge. An administrative warrant, signed by an ICE official, does not give them legal entry to a private residence without consent. Beware, a command voice might frighten one to consent. Don't be. But note, an agent can arrest a United States citizen who physically interferes with an active investigation, obstructs an arrest, or assaults an officer. In these cases, the arrest is for a criminal offense, obstruction of justice, not for an immigration violation. Knowing one's rights avoids that possibility.